All right, so I'm going to do a quick video just looking at some jargon that's kind of often used within the homelessness sector that kind of concerns homelessness law. This is kind of in part because for those people coming on the online training, this is just a video just to kind of introduce some terms to you, but you don't need to remember all this stuff. You don't need to memorize it or anything like that. This is simply just to kind of, I guess, familiarize yourself with the language that we're going to be using on the day. And I guess just kind of clear up some potential misunderstandings as well. So yeah, it's boring. There's no getting around that, but it is useful. It does make a difference just kind of knowing what these terms mean. And the first term I'm going to look at, or group of terms, is this idea of a housing authority. So that's the kind of the term that's used throughout the law and the guidance. But in kind of layman's terms, that really is your local council that has a housing options department. Can also be called a local authority. In a lot of areas, you've got unitary authorities, and what that basically means is that all the council, so there's basically one council in the area. So social services, housing will all be under that one roof. But there are also two-tier areas where they've got, a district council and a county council. And what that means is often the social work department will be in the county council, and the housing department, the housing options team, will be in the district council. So it's important to understand there is a distinction. It is easier to work in areas where it's a unitary authority because they're all under one roof, so you don't have to keep going between two different councils. But obviously the law applies to both. So that's the first term. Second term, household and applicant simply is the family or the individual who is applying to a council, a housing authority, for help with housing. So, that's kind of the language we use. It might be client, might be individual or whatever, but the household and applicant it tends to be the language that's used by the Code of Guidance, and it is kind of helpful just to understand that's what that means. Next up is that term duty. Now, duty is a term you'll see throughout the housing law, and some councils obviously think that it's kind of a loose kind of guidance kind of thing, but actually, if you look at the language of kind of sections like Section 184 of the Housing Act, which is a kind of a big important one that we look at on the training day, basically there are various times where a council has to do things. So, for example, the most important one is if a household or an applicant applies for housing assistance from a council, from a housing authority, and gives that council reason to believe they might be homeless, the council shall do X, Y, and Z. So it has to happen. As I say, it's not just if the council kind of feels like it that day. And there's an interesting thing where we've been going through 10 years of austerity already, likely to have a good few more years yet of it. Lots of the kind of statutory guidance, a lot of the kind of the law around these kind of areas of kind of, protecting vulnerable people, make the point that when your resources are strapped, it's all the more important that you are doing your duties, you're following your duties as a council. And on that kind of topic of duty, as a caseworker, or an advocate or support worker, whatever whatever term you want to use, the main homelessness duty or the main housing duty is basically the holy grail, because the main homelessness duty or the main housing duty, doesn't matter which term you use, is basically where a council has finished their inquiries and they've established that they have a duty to provide settled accommodation to a person, to an applicant or a household. And that, as I say, that's often for many people going to be the best offer of housing available for them. There are lesser housing duties within the Housing Act. So, for example, if you're in priority need but you're intentionally homeless, the council's got a duty to house you for a good 2 or 3 months before their duty ends. But obviously, that main homelessness duty is the one to go for, because often people who get housed through the main homelessness duty do not become homeless again. So it's kind of good way out of homelessness, basically. And where a council's got a duty to do something, it can discharge that duty lawfully, i.e. it follows the law, or it can discharge that duty unlawfully or illegally, where basically it doesn't follow the law. So, for example, a council might have a duty to carry out inquiries, and if it doesn't do that, it's discharged that duty unlawfully. And in some situations, you can get compensation through the local government ombudsman. The ombudsman or the LGO is a little bit like CQC or Ofsted, but for councils, and their job is to make sure that the councils follow the right process through the in relation to an individual or household or applicant. The LGO can't look at actual decisions themselves. So, for example, if you've been found to be not in priority need and you don't think the council's got it right, there's no point going to the LGO because that's something which sits outside their remit. They are looking more at, did the council accept the homelessness application when it should have? Did they carry out the inquiries in a timely fashion? All that kind of stuff. Was the accommodation suitable for them? So that's kind of, or did, no, not even that. Did the council respond to complaints about suitability within a timely fashion? That kind of thing. So, as I say, the LGO can recommend compensation. It's not huge amounts. It doesn't really reflect the severity of the transgression of breaking the law, of a council breaking the law, but it's better than nothing. And if you've got nothing, then a few £1,000s is something towards a new start. So, Acts of Parliament. So we talk about homelessness law. What we're really talking about is a kind of a group of acts of Parliament. So these statute law, whatever you want to call it. Primarily, it's the Housing Act 1996. But the Housing Act 1996 has been amended. It's been changed slightly by subsequent law. So the Homelessness Act 2002 introduced kind of new categories of priority need through vulnerability. The Homelessness Reduction Act brought a whole raft of really complicated, onerous duties on councils, which often don't make any difference to a person. But anyway, you've now got the Domestic Abuse Act, which is a genuinely kind of good thing that's happened. And you've also got some other stuff that came out of the Localism Act around local connection, stuff like that. So essentially, that's kind of what we talk about when we're talking about acts of Parliament. And as an aside, we live in a democracy. We vote in people to represent our interests. These people then come together and they debate these laws. And so in one sense, the Housing Act, or whichever act you're looking at, it should be a representation of what the people of England want. And so for a local council, for a local government to frustrate those laws, that is a serious thing. That should be something that's not happening. Yeah, it's happening every day in the country. So, but if you ever try reading the Housing Act or kind of these other acts I've talked about, it is not a good place to start to kind of get your head around housing law, because it's written in kind of really kind of jargonized, high legal kind of speak. And in one sense, the bit you want to focus on are the codes of guidance that kind of come alongside of these different laws. So the main one is the Homelessness Code of Guidance, but there's the Domestic Abuse Guidance Framework, and they are basically where they go into a lot more detail. So where, the Housing Act will say a council's got a duty to carry out inquiries, the Homelessness Code of Guidance has a whole chapter about what that actually means, and that is written in layman's terms, which is the best place probably to start with. I would say any homelessness professional or any professional that deals with people who might be homeless in their course of their duties or their kind of role, they should have a Homelessness Code of Guidance on their desk, and that Homelessness Code of Guidance should be scribbled all over, because because it helps you kind of get your head around it, and you often want to refer to kind of paragraph numbers and stuff like that if you're advocating for someone. You've also got case law. The other thing I didn't say about the Code of Guidance is, although it's called guidance, it's basically legally binding, so a council has to have an exceptionally good reason to ignore it. But we've also got this kind of idea of case law. So where the Housing Act might kind of make a statement like, people who are vulnerable are in priority need, that is so open to interpretation, it's unbelievable. What happens then is individuals, so households or applicants, then challenge through the courts council decisions, and those decisions change the law's interpretation over time. So vulnerability is a good example. Vulnerability is a very complex issue within homelessness law, vulnerability that leads to priority needs. And basically various cases have changed that over time. So in a good direction, it's got to be said. So, really the kind of the threshold of vulnerability is coming down and down and down. But when you see decision notifications, which I'll come to in a minute, when you see these letters from councils cite things like HOTAC or Lomax, and you're like, what the hell's that? They're basically just the individual household that case was about. So, for example, HOTAC was a big case about the interpretation of vulnerability, and that's what it's just referred to. So, the definition set out in HOTAC would just be referring to that case. And in a lot of these cases, if you really want to get into it, you can get them through, you can Google them basically. So you can see the entire transcript of that case, which will go into a lot of detail. It's probably too much, probably a bit too much that you need to know. But if you really want to kind of hone in on what vulnerability means, for example, you want to get into those kind of cases. And as I just mentioned there, decision notifications, basically often or at various points within the homeless application process, a council's got to make a decision about something. And in most cases, that decision will need to be given in writing, and they'll need to explain why they reached that decision. And they'll also need to explain how you would challenge it if you want to challenge it, if you don't think it's right. So one of the key things, if you are an advocate, certainly the first question we ask someone, if they say, oh, I've been to the council and they said, I've told them I'm homeless, and they said, I had no local connection or something, we'd be like, okay, did they give you that in writing? Did they give anything in writing to you which explained why they said that? And often the answer will be no. In one sense, some housing officers, the dodgy ones, will be perfectly happy saying things over the phone or in an interview, which they never dream of writing down in a decision notification because it's so clearly unlawful. So getting that decision in writing can often be enough in some cases just to get that person housed without you having to do anything with it. Just that request of giving the person the decision in writing will in itself get the council taking that person seriously when before they may have not done. Nearly there. So a couple more things to look at. Temporary accommodation. Lots of accommodation is temporary, obviously. So night shelters, refuges, and so on are accommodation, which is temporary. But when I talk about temporary accommodation, and when my colleagues talk about temporary accommodation in the training, we're talking about something very specific. And basically what we're talking about is accommodation that's been provided by the housing authority, by the council, as a result of them having a duty to do so, because someone's made a homeless application. We'll kind of come to where that will kind of kick in. It can also be called interim accommodation. And basically sometimes when the council's actually finalised the decision, they will continue often to have a duty to provide temporary accommodation until that person gets their offer of settled accommodation. So it can be a real range of things. Some temporary accommodation is great, certainly in Bedford Borough Council. Some of the temporary accommodation is absolutely brilliant, really kind of high quality stuff. Other bits aren't. Some councils use really shoddy, are known for using really shoddy quality accommodation. Sometimes it'll be B&B, sometimes it'll be hostels. There are legally any accommodation they provide should be suitable, but often it isn't. So that's something which is just important to bear in mind if you're supporting someone through that process. It doesn't have to be furnished. It could be very cramped potentially, because it should only be temporary. But that's kind of what we're talking about here. So when someone makes a homeless application, if the council's under a duty to provide temporary accommodation, they have to offer it. They could also offer they could offer a refuge, or they could offer a hostel or something as well, like a supported housing, but they have to offer the temporary accommodation as well. They can't say your only option is staying with a friend, or your only option is to go to a refuge, provided there is a duty to provide temporary accommodation. They have to offer the temporary accommodation as well. And in most cases, it's in the person's interest to accept it, over a refuge, which might be 200 miles away or whatever. So that's TA, also known as TA, temporary accommodation. One thing that's worth saying is that within all these definitions we're talking about here, and the training we do is almost all centered on Part 7 of the Housing Act. So Part 7 is everything that deals with homelessness. There are obviously some other parts as well. The most relevant being Part 6, which is all about housing registers. However, we don't go into too much detail in the kind of introductory courses, because legally speaking, if someone applies to a housing register and they give that council reason to believe they might be homeless, it should be recognised as a homeless application under Part 7. So in one sense, Part 6 is kind of where, there's not a great urgency to get housed. Where there is an urgency because you are homeless or you're threatened with homelessness now, it should be dealt with as a homeless application under Part 7, not as a housing register application under Part 6. There are a couple of other kind of points where it does cross over as well, but I won't overcomplicate things now. And then finally, particularly for the domestic abuse course, but it's relevant for the other courses we do as well, you've got lots of acronyms like MARAC, DASH, IDVA, and we do talk about them in more detail in the training, but essentially, these are acronyms that relate specifically to the domestic abuse sector. So the MARAC, for example, stands for Multi-Agency Risk Assessment Conference, and it's basically a group of relevant professionals looking at how best to support a victim of domestic abuse. Often to get to a MARAC, you need to be referred through a DASH form, which is Domestic Abuse, Stalking and Harassment form. And basically, it kind of depends what score you get out of those questions that will define whether you go to the MARAC. And also the term IDVA, Independent Domestic Violence Advisor. Don't ask me why they're still calling it domestic violence, but they are. That's basically a professional who is there to support, often for quite a short space of time, support people to manage risk, and often will actually support that person to approach a counsel. But there's lots of other acronyms we'll come to as well, but they're kind of probably some basic ones to kind of start off with. That's kind of all I'm going to talk about now. If you're interested in training, if you're not already coming on it, if you're just seeing this on YouTube or something, check out justus.org.uk and just look in the training tab. You'll see kind of a list of upcoming training dates. We deliver training on homelessness law. We do stuff on the Care Act, drug and alcohol stuff, complex trauma, data protection. We've got quite a good range. We're looking at developing some new courses as well. All reasonably priced. At the moment, it's all online. Whether we'll go back to face-to-face, I don't know. But I would say, we get really good feedback. Genuinely, I'm not just saying that. In one sense, we're not making a whole load of money off it. We're doing it to kind of fund other aspects of the charity as well. So some of the money we get from it goes to furnishing people's houses and campaigning, all that kind of stuff as well. And if you go on Facebook, Just Us Homelessness Advocacy Bedford. Again, if you check out the events tab, you'll see upcoming dates, and kind of costs and stuff like that as well. But it's the stuff I wish I knew when I started working in the sector 15 years ago. So that's kind of, that's the point we're coming from. We're trying to provide the information that is essential for people to know in order to get people housed. So hopefully that makes sense. And if you haven't already, just subscribe to the channel, just because it helps us get the message out there. Feel free to share videos on your other social media things, LinkedIn or whatever. Twitter, is LinkedIn still a thing? It probably is. Facebook, all the rest of it. Just get the message out there. Hopefully I'll see you soon.